Yeah, I was wondering, I had filed like a 1099-C on my Social Security number, and but I want to find out any 1099s, ABCs, anything that's been filed on that. Is there a particular on the transcript? A lot of times they don't cover all the the forms. Is there a certain form that I could get that information?
Um, I did see something about that. I think it was this morning. Like, there is a way to do it. Um, just have to figure out exactly where it was posted, though. Um, Short answer is yes. Um, but going off of my recollection, you need to notify them that there's been it's like flagrant identity theft, aggravated identity theft of your social, and you have to FOIA the IRS and the individual master file. That has all the records of every entity that's ever submitted 1099As or the first B against your social person. I wish I could remember exactly where
Wow,
that's at.
that would be great because I'm like 72, so there's going to be a lot of activity out there.
Right. I mean, because once you have the 1099As that everyone has submitted against you, you could see which entities have actually put claims upon your social trust. And I saw that and I was like, wow, that's how we do that. Not that you can't, submit the request, the Numident report via Social Security to see which entities have accessed your social. But your question more geared towards 1099 that had been levied against the account, or not levied, but ledgered.
Oh, so you're saying we could actually find out who tapped into our Social Security fund?
Yeah,
Is that what you're
yeah.
talking
There's
about?
a way
Like
to
when
do it. Um, it's in the group. I forget what channel that's in, where it was discussed. Um, but it is the Numident report. But the Social Security website is so convoluted. You cannot request a living Numident report via the website. You can only request a dead entity report, which is confusing because the social is a dead entity in and of itself, but it's not categorized that way in their systems.
I remember reading some of that in the Social Security chat.
Thank you. Yeah, so it's in there. You need a living Numident report.
Okay, thank you.
Yep. I do recall some people that did that in the past. And I actually did it in the past too, and we got responses such as, "We're not authorized to access that information." And someone or a couple people had posted about a way around that. I never pursued it. So I was like, I'm moving on to other different things. I can deal with the IRS easier than the Social Security Administration. All right, for
I have a
everyone else who's
question.
on, welcome. Okay.
What?
Which question?
Yeah. So I created an account on Free Tax USA. I think that's what it's called. I'm just looking how to file for free. And I didn't see that they had the 1099A, B options to do the claim your credits filings. Are people doing that there? Is there a way to find those forms, or are people using it for other forms and not the claim your credits process?
You can. It is buried inside of there. It's like, business filings. But it's not user friendly. The easiest way to do 1099s, to submit them, is having an Iris account. and that requires a sole prop. That's the easy way. There are various third-party sites that allow you to do 1099 A's, B's, and a slew of other ones. They vary by services provided, but you have to pay for them. Versus using Iris is free.
Yeah, I've asked in the group a couple times, and it seems that, so I thought I could use my Social Security, blue card entity person as a sole prop because it is a sole prop, but apparently my Social Security number entered into the EIN box on the form, they don't accept that. So I think it was you, Stephen, or maybe someone else recommended that I get a sole prop, and do it that way, but I don't know that that's the right route to do, is to create a sole prop just to file the claim your credits filings. Is anybody else doing that? I don't know. That seems weird to me. I'm trying to do the trust, the trust filings with claim your credits forms.
Yeah, no, it's you have to. I think it originates from when they reclassified the SSN. How it used to be identified as an employer identification number, but they reclassified it to an SSN, and that classification precludes it from being counted as a business in certain systems. So in order to get around that, you have to create a standalone sole proprietor business EIN from the IRS, and then you register an IRIS because that is purely for air quote businesses as defined within federal regulations. And then you have to use your social inside of it in IRIS to identify the individual who is responsible for the business, which is hilarious. So it's just a convoluted matter.
Yeah, kind of complicated.
Yeah, because they created the bureaucracy that people couldn't fully utilize it, right? Because they wanted to monetize it on multiple layers. So we want to create new categories of people, give them licenses, tax, in order to do things like submit a tax document. You must be a licensed tax preparation specialist, or you're doing it for, quote, yourself. Because it's just a way that they can merge it and, confuse people to believe that you, the individual, are the social that the government owns. You are government property. That's why they do it. Right? It's a giant psyop.
Yeah, right. So the way around that is to actually go and get an EIN for the sole prop and just claim the social number as the individual responsible for the...
Right.
Okay.
Yeah, because that's all a sole proprietorship is, right? It is a sole proprietorship ran by a singular Social Security numbered person. They're using the legal definitions of things.
Yeah.
So that's how they want to run it.
Thanks. Yeah.
Yep. Good question. I believe someone else had wanted a question.
Oh, Steve?
Yeah.
Oh, just for clarity on what she was asking. So if I had a 1099-C that I filed on my Social Security number, and then I went out and I wanted to get it on the transcript, would it show up if I, like you said, if I file a copy of that 1099-C on the IRS, would that show up credits on my Social Security number?
Yes. That would definitely show on your Social Security number if it's filed against the social. Just got to be aware that any amount that's indicated on the 1099-C would be considered as income to that receiving entity. And that would be that could trigger a taxable event.
Okay, thank you.
Yeah. Because this is basics, kind of getting into the basics, but more advanced stuff is you create a trust, and your trust takes claim of property and cancels the debt. And trusts, when properly structured, are non-taxable entities. So if they have income against them, they're non-taxable entities. They can expense with things prior to having to pay bills or taxes. Unlike the social
Right.
person, it can't.
But sometimes, like what I had the non-decedent already set up, and I had transferred some income to it, but they ended up sending me a bill for the taxes on it, even though it was tax exempt.
Right. Because they're checking you. See if you know what you're doing.
Okay, because I did
Right? Because
respond.
if you're running a trust, bills come first. Like if a trust is ran by a trustee and the trustee is receiving compensation, that compensation is deducted against any potential income that the trust could have. Think about that.
I have a trust
You
question.
make sure.
Oh, sorry. Go ahead.
Okay,
Yeah.
but
Just 1
basically,
second. So you got to make sure that your trust documentation is on point. Like you have your meeting minutes, you have your trustee having signed off on those meeting minutes, discussion compensation packages, you got your ledgers indicating the hours that your fiduciary and or trustee have completed tasks related specifically to the management of the trust and its assets to maximize the benefit to the beneficiaries, and you have the compensation for those hours documented, sign off by the trustee indicated in those trustee minutes that you have compiled, and you ledger that as expenses against your trust. So any income associated is offset, right? Balance the books.
okay, but a compensation to the trust or the person, then they're going to be obligated to what they received from the trust, the fiduciary or the trustee.
Depends on if you have your ducks in a row. Because according to the law, any fiduciary who is executing their duties in regards to a trust is allowed to be compensated, and it is not earned income. Right? That's a legal definition. Earned income.
Oh, great.
And is how the ESV process, the Christina Wilson process, that's how that works, or why that works?
Yeah, it's all about knowing the law. So if you follow the law, or said simpler, if you play by the rules, you win. There's lots of rules. So there's lots of wiggle room. You just have to know them, which is how we've all been taken advantage of for a very, very long time, because we didn't learn the rules in school, and we always thought the IRS is the bad guy when they're the only one that's playing by the rules, and they expect everyone to know the rules. So when we say, yeah, I'm a complete, mature, capable adult, what we're really telling them is, I know all of the rules, and here's my evidence, here's my paperwork. But we never learned the rules. Or we were told that the rules were bad and we need to stay away from the rules. So we did. So it's almost like someone wanted us to become indentured servants for the rest of our lives to make them rich. It's almost that way. I mean, it's kind of a weird conspiracy, but, it seems to be true.
Yeah, I just have a question about like amending a trust. So I'm still new to all this. I'm just setting up my trust, and I followed Kia's trust template. I did read through all those 21 pages, and I edited it according to my needs, but I didn't really edit much. In the wording, it talks about anything that I might acquire, going forward. But so my question is, as I've been learning about trusts, I hear people talk about, I put my car in a trust, I put my house in a trust, and all these things. If there's, like, I don't own a house, but I own a car. I didn't specifically list the car in Schedule A on my trust. So my question is, how do you amend? Is it necessary? I keep hearing people talk about these things being listed in the trust, and it kind of makes sense to me that if anything ever were to happen, it would be good to have it like documented the car, the maker, the VIN number. So it's private, right? So do I just amend my Schedule A, or do I have to add a separate document to my own paperwork and that I keep in my files because it's private anyway, and I just say I'm adding this to the trust? Like, how does that work? How do you amend a trust? How do you add, assets to it? Hope that's clear.
Yeah. I'll restate it, just so that we get more specific. So your question is, in regards to a revocable living trust, how does one move assets into it and properly document them on a Schedule A? Well, you can think of it as your social security number person is a trust. And a revocable living trust is very similar. Very similar. I believe the SSN is actually an irrevocable trust, and we're merely beneficiaries of it. And it's created at the beginning, and the trustees are appointed, fiduciaries are appointed. That's like the Secretary of the Treasury and the Director of the IRS.
Yeah, that makes
and a
sense.
couple other people. So they're the trustee and the fiduciaries. And then all the federal agencies are agents of them who administer under delegated authority. So that's kind of like a revocable setup. But the revocable is the trustee can modify all of the terms of the trust. So it's merely you sell it to the trust or you transfer the title, right? Like if you have a house, it's a quit claim deed, or you just straight sell it to the trust. If the trust has the assets on hand and they can do a fair exchange. That's also possible. But like a quit claim deed or a change of title, if you own your vehicle outright, that's merely just you're selling entities and you just pay the government to update their records to indicate the true new owner. And you provide them the details of the new owner, which is the name of the trust, the identification number of the trust, the address of the trust, or the mailing address of the trust, maybe the physical location of the trust, or estate. It can be all of those things, or a couple of those things. Now, when the trust is acquiring it, they have to update their records.
Yeah.
And the easy way to do this and to keep your records straight is to hold a meeting between the trustee and or the fiduciary and or the third party that they're acquiring the asset from in order to identify the specifics of the transaction, like what it is, where it is, the condition it's in, the price that's being sought, and the agreed upon amount, when that payment will execute, and when it has completed, and if all parties agree, and then the trustee signs off on that. Right? Now, it gets kind of convoluted sometimes because it's you. You could be the trustee. You could be the fiduciary. You could be the third party selling the thing to the trust. Now, you have to role play because that's what we've been doing our entire lives. You've been role playing without knowing it, most of us. So you have to split these things into separate roles. You have to act according to your role and to perform your duty of that role alone to the best of your ability. And come to an agreement, document the results, sign off on it, pay for it, update your records. Then go update the government records. Have another meeting, trustee, they can do it alone, where they document the things that they have done in order to meet the transactions. You say, I did this. This is what I did in the past in order to fulfill the contract that the trust had with the entity selling the thing to the trust. Here's the details. Here's the receipts. Here's the payment receipt. Could be a bank statement. Could be a picture of whatever the thing is that was the agreed upon payment. Here's the updated records, and we're updating our Schedule A to include this item. It shall be identified in trust record number, whatever method by which you do indexing of your records. Sign off. It is now property of the trust. The government has been updated. Make sure you do insurance if you're carrying insurance, because they need to know these things as well. And they might just, change your rate because they love to do that. And that's it. That is how anything gets transferred into a trust, more or less. The details will be wildly dependent upon who's doing what, when, where, and how.
Yeah, sure. It's a matter of like kind of being an accountant, and you just have to like do a lot of paperwork and make sure that every little detail is documented. So
right.
I just need to write out a document saying that all caps, name written in all caps is, transferring or selling my car, make, model, VIN number, blah, 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 into name of trust, and in the care of the trustee. And then I write my name in my trustee name, lowercase. And then I just file the paperwork. And if I need to go to court or whatever, if anything happens, then I can produce the paperwork. But it's just, having a conversation with myself. And really, I just need to sit down and write it out and date it and then file it away.
Right. Yeah, because it's no different than saying Jane Doe is getting with Carfax to buy car. Carfax has this make, model, year of car and condition, and they want this amount. Jane Doe wants to buy it. This is the agreed upon amount. This is the date of sale. Here's the copy of the contract signed by both parties. Here's the agreed upon payment schedule, pay in full or pay in installments. And here's the receipts, bank statements, checks, what have you. Or receipts for in-cash payments, if they ever do that, again. And here's the updated government documentation identifying the owner. Now just switch the names. It's not Carfax, it's your trust. And it's not Jane Doe, it's your name. Because you're the social person. Now the witness is the trustee, right? Because the trustee isn't the trust. The trustee merely manages the trust. They're the witness.
Yeah, and then so once I have that documented, the documentation with the outside entities, whether it's the DMV or the government or whatever, the transfer of title, so it moves from my all caps name and it needs to be moved into the name of the trust.
Right, because then it's the property of the trust.
Okay, yeah, thank you, got it.
Yep. And then once all of that is done, here's an important part not to be skipped over and touches on a previous question. Make sure that the trustee is documenting their hours that they're working on this. That's billable hours, right?
Yeah.
Because anything that the trustee does related to the trust to manage the trust's assets is work. So documentation, while some people absolutely hate it, is paramount. It's the only evidence in some cases. Absence of documentation means it never happened.
Yeah. Thanks.
Yep. D-Train, you got a question?
No, I'm sorry. I'm sorry.
Steve, I have a question. Hi.
Hi, RP, what you got?
Speaking about the trust, okay, so I have an irrevocable living trust set up at the bank, and I have this vehicle that I have a purchase order for. How would I go about getting the bank to honor that PO for purchase?
Please elaborate by what you mean by getting the bank to
Um,
honor it?
to accept the purchase of the vehicle through the trust as the
So do you
trustee.
mean, how would you get the bank to acknowledge a negotiable instrument and accept it as payment?
Right. How would I go about
Well,
doing that? Because I do have the PO and I've been sitting on it just for a few days trying to figure out how do I approach the trust account to purchase this.
well, this is something I haven't attempted. So I don't have practical experience answering that question.
Okay.
However, the theory of it is, since you have a trust who has a purchase order, that trust desires for a financial institution to act as a fiduciary in order to take a promissory note for payment in the amount of the purchase order, plus or minus fees, in order to take that to the Fed window to redeem it.
Right.
Now, you will not be able to accomplish this with a retail establishment. They don't do that.
Okay.
You're looking to find the trustee of a bank. And that information, you would have to go through the 1099K filings? Not the 1099Ks, but yeah, no, it's the 1099Ks, the distributions based upon the beneficiaries of the trusts.
Mhm.
You'd have to find those for those corporate entities that hold the public-facing banks, right? Because most of the banks are private entities, usually trusts,
Mhm.
and they own the retail side. So the retail won't help you, probably because they're being directed not to, because that would
Mhm.
upend their entire system. You'd have to find the trustees and then present
You have to
them
find the
with
trustees
it.
of. Okay, you have to find the trustees of the bank. Is that
Yeah.
what you're saying? Okay.
Yes. Because they're the ones that can direct the banks, the retail side,
Mhm.
on
Mhm.
what to do, right? Because really you're doing a trust to a trust transfer.
Right.
So
Okay.
they would have to get involved. They would definitely want their cut, no doubt about that.
Right.
They might actually charge you a lot because that's like, that's a
Right.
private dealing.
Right. Okay. So my best bet is to find a trustee and send that information to them along with instructions, perhaps, or trying to let them know what I'm doing and see if they will honor that. Is that what you're saying?
Well, I think it'd be more in line with find them
Mm-hmm.
and inquire as to what information they would need in order to accept
Okay.
a negotiable instrument for
Mhm.
redemption.
Okay.
Because if they're acting as a fiduciary, and that most times there's different individuals for those roles, the fiduciary must act independent. So they might respond, they might not respond, depending upon what's considered in the best interest.
Mm-hmm.
So you need to find the information on who to contact first, then ask them, what information do you need in order to complete this type of transaction? If they want to complete it, they would probably respond. And then you'd go from there.
Okay.
Right?
Well, I have
Because
one.
you're trying to get into the back alley
Right.
financial dealings. So
Right,
they may
I have
not
it.
acknowledge it whatsoever.
But what about Fidelity? If I have a Fidelity account, would they be more accepting as far as honoring that, you think?
Depends.
But the thing
on a lot
about
of
that
things.
is It is not a revocable, it's an irrevocable trust set up with Fidelity.
Right. Well, I mean, that's not really too much of a factor
Oh, okay.
because it's what's in their best interest,
Uh-huh.
right? Because all trustees and fiduciaries are supposed to act in the highest and best interest of their beneficiaries. One of those considerations is, would this activity negatively or potentially negatively affect what's going on already? So if there's not a clear benefit to them, it may not be in their best interest.
Okay.
Right? Which is how they can get away with the take your promissory note, flip it to the Fed,
Right.
get some money, put it in escrow, have you sign an additional contract where they get paid out twice, sell that once or twice or 5 times, hypothecate it, then buy a bunch of treasuries with it so they can get massive gains. Why wouldn't you do that?
Right.
Because that's to the clear benefit of your beneficiaries. Helping out someone for only an amount where they can only maybe get 5%, whereas they can, rake us all over the coals and fleece us for everything we're worth and get 100% or
Right.
10 times the amount. Which one is actually in their best interest? Not which one's legally or morally correct, what's in their best interest.
Okay.
So it's not that you can't do it. It's just we have to appeal to their greed in order
Right.
to play in their game.
Okay. Thank you.
Yep. It's a good question.
Thanks.
Who else has a question they want to ask? Or they want to share? And if you don't want to say it out loud, if you could put it into the Recoupers live session chat. Because if you're doing it in the chat for this live, I can't see it because I'm running it.
May I?
Please.
So a couple weeks ago, you were talking about on your live chat, I believe it was you, Stephen, you were talking about when you get third-party debt collection notices. So like
Right.
on that one, it was an attorney acting as a debt collector. And you had said something about, was it the Fair Debt Act that is a violation of? Is that right?
Yeah, the Fair Debt Collection Practices Act, the
Okay.
FDCPA.
What if it's not an attorney? What if it's trans world, whatever, some debt collection agency that bought the debt of that all caps entity after it was charged off? You know what I mean? Because Discover, all of these credit card companies, when you don't pay it, they charge it off. Then they bundle it as a securities package and they buy these securities bundles. And then those
Right.
entities go out and try and collect as if they're acting on behalf of the original so-called creditor, right?
Right.
So all of those are third parties and they're all in violation of the Fair Debt Collection Act, correct?
Yeah. And truly, here's one of the things that is often misunderstood. If a alleged creditor charges off an account, right? That's a 1099-C event. They report it to the IRS. It goes against the Social Security number's earned income as it's been written off. That right there is a nullification of a debt.
Right.
They cannot legally sell it. Right?
Right.
That's
But
double dipping.
none of them are doing is the 1099-C. Because then they have to report it as income and be taxed on that income, right?
Oh, no, they don't. They get a business deduction. The entity that they did the 1090-C upon has to pay taxes on that income.
Oh.
Right? And
Right.
they can, the only real way to check, right? Because here's how some companies do it. they declare an item as a charge-off, they will wait until the end of the tax season window to file the 1099-C. Right? And their window is determined by their organization. So it does not align with the regular individual tax filer window.
Right.
So there may not be a record until after their tax year closes. And they can just say, oh, we charged it off. Which, if they update the consumer reporting agencies as it's a charge-off, a demand can be placed for that 1099-C because that's an inaccurate filing, right? That's the Fair Credit Reporting Act, the FRCA, or the FCRA. So if there is no 1099-C, it cannot be reported as a charge-off. And if it's reported as a charge-off, it can't be sold to a third party because if you're charging it off, why just sell it? Because you could sell it without charging it off.
Right.
And still wait until later on to say, we closed it out, we sold it. Here's our business loss.
So if one has the statement showing where they declared that they charged it off, okay, if you have that final accounting from them that they charged it off, then that's your evidence that they should have filed a 1099-C, correct?
Yes. Otherwise, they're in violation of the Fair Credit Reporting Act, and they can be challenged. And they will lose.
So then you should ask them for a copy of the 1099-C where they charged it off, where they reported it charged off.
Yeah.
And if they fail to provide it to you, then you're done. No further action can be taken.
Because they have lots of leeway in it, right? Because like you can challenge it and then they say, oh, that's our bad. They update the CRA, the Credit Reporting Agency. So then the credit report is fixed, air quote fixed. But then they can sell it, or they can just go ahead and do that, file that 1099-C at that point. And then you'll get the third party coming after you, or it'll just pop up on your transcript on the IRS, which is great. Like either way, it's great because if they sell it and a third party comes after you, the Fair Debt Collection Practices Act specifies all the different things that they can do. And there's lots of entities out there or influencers on YouTube, TikTok, Instagram, who go and talk about these things like a lot. Like they can, off the top of their head, quote you 15 USC, 16 USC, tell you exactly what particular line of the law they're violating. Right?
Which are many most of the time. There's many lines of that law. They just expect you not to know what those are and not be able to hold them accountable.
Right. Like, you know, it's not really often understood. If you have a negative item in your credit report and like you say, you want to get a home loan and you're denied, and the reason for that home loan denial is this particular negative item, you can sue the person or the creditor who put it on your credit report and sue them for the damages that you lost. Like you want a home loan, $250,000, $300,000. You couldn't get it because of the item that they put on there. You sue them for treble damages. That's the letter of the law, because there's no negative item that is allowed in the law. It's the law. And you have verifiable proof. Just go to the credit reporting agency, pull it down, save a copy of it. Boom. You have an Exhibit A. And you just have the law. They can't beat it. They do only the things that they do because people are unaware and allow it to happen.
Exactly.
Tacit acquiescence.
Exactly. That's why your side of the road police officers get away with what they do, because nobody challenges them with what they're doing, with knowing the law. They're enforcing a law they don't even know. You know, same thing over and over again. Multiply that out times every entity, agency, whatever out there. It's the same scenario, right?
Yeah, exactly. I mean, because like Jeremy particularly has said this many times, and he continues to put it out on his TikToks. Most individuals in law enforcement are violating constitutional rights every single day. every day, multiple times a day in some cases, for the most minor infractions.
Right.
It's
Did
because
you
the
know?
law enforcement doesn't know the law.
Did you know that this is off topic, but did you know that the State Department gives training, provides, air quotes, provides training to law enforcement officers, which none of them take, and the very first question they're supposed to ask whenever they pull anybody over is, are you a U.S. citizen? Did you know that?
I did not, but I can believe it wholeheartedly.
And none of them know it, and none of them do it because they take their training from what? Attorneys.
Right. Like, why would I need to know the law when I can do what this entity that has its allegiance to the foreign crown says? Why would I want to know the law of my country when I will do what the operatives of a foreign nation tell me to? That sounds like sedition to me.
Treason even.
And treasonous
Yeah.
even, which, Jeremy said this a lot. They are all, most of them, performing seditious, treasonous acts, and they don't even know it. And they take it as a challenge because someone's asking them questions. They're saying, you can't do that, because they don't know the law.
Right.
Which is mind-blowing.
It's sad, isn't it? It's really sad.
Well, we don't know the law either, so we can't hold them accountable and we can't do anything about it.
Well, that's why you
Right.
got to learn the law so you can hold them accountable.
Right. Because if you know the law, well, then you're nothing but a age of majority individual. You're not a minor anymore.
And now you're
know
a
how to use the law.
lawyer.
Yeah.
Well, thanks for answering my questions about the debt collectors. That helps a lot.
Yeah, I mean, there's a massive amount of fraud perpetrated by debt collectors, right? So, I mean, even at one point in time, one of the guys that I watched a lot, maybe like 100 hours worth of his stuff, joined this group, and he always joined under a pseudonym, and I recognized it, and I accidentally called him out on it. I think it was back in February. So they are aware, like collectively, they are aware of groups like this doing what we do. There could be some still in the group with different, pseudonyms.
I think you had one of those on your call a couple weeks ago, because as soon as he started talking and saying what he was saying, I'm like, you're a liar. I can tell. I'm not even on. I was listening to the recording. Wasn't even on there live, and I could tell he was lying to you. Like, no, you're not. You're an attorney or something that's trying to find out what we're doing here and what our processes are,
Oh, yeah. But see, that's the beautiful thing about learning the law. It doesn't matter if there's agents in here.
Right on. It doesn't matter.
Right.
You're right.
Like, I know it.
'Cause now-
I've had conversations with several of them, and
Yeah.
it doesn't matter because my entire thing is learn the law, follow the law, do only what the law says. And if it doesn't apply to you, great.
Ignore it.
That's it. I mean, yeah, I know a lot of us, we went through rebellious phases and we're like, I'm not going to do that. I'm going to do my own thing. Like, no, you need to know who you are, know what you're capable of, know what, when, where, and how to act, and you're good. Do what you want.
Yeah, don't be a belligerent. That'll get you nowhere.
Yeah, don't be a belligerent. Don't be a threat. And if you're acting as a trustee, at all times, you must be cognizant and you act in the most beneficial behavior and actions to benefit your beneficiaries. Being overly aggressive and threatening to another individual in public is not that thing. So it's always best to be nice, cordial, respectful, know the law. Know the rules of the game. Play the rules. You'll win. It might take you some time, but you'll win. Cheaters will be found out. The current, administration it appears to be extremely hard on people who are breaking laws recently. So they're going to find the people that are breaking the laws. Stick to the laws. And that actually kind of goes back to something that was put out several months back. I think it was May-ish. With foreign grantor trusts, if you don't have a foreign grantor, you might want to stay away from that type of entity. Because if you don't have a foreign grantor, there might be fraud there. And the government seems to be cracking down a lot on fraud at the moment. It's just a friendly suggestion. Not saying anyone is doing it. But if anyone who has questions about doing it, there are people in this group, I don't know if they're in the call necessarily, who are in different countries who really want to make this stuff work, and they need a local trustee for a foreign grantor trust, right? So there are people in the group looking to make that stuff happen. In fact, there's one who's in a different country, for real. So I'm not sure, do we have a particular channel for foreign grantor? I don't think so. But in one of the trust chats, if someone's trying to set up a foreign grantor trust, try to connect with those people who are in different countries who want to set up trusts. Right? Teamwork makes the dream work. If you have the time and inclination. The option's there. All right. Who else has something they want to ask a question on or tell us about a success that they've had?
I do.
Hello. Welcome again.
Yes. I was just going to ask a question regarding what do you feel the best thing that you should do in order for the powers that be, the cops on the street, courts that you deal with or whatever, that would let them know that you're claiming your status. And I know the declarations of status will do those things, but what is the most powerful thing that you've dealt with that will facilitate that?
Well, my opinion on it would be, in order to successfully put them on notice that you have a status correction, or you're correcting the presumption of your classification so that you're outside their jurisdiction, your proficiency in the law and knowledge of your rights needs to be at top level First Amendment auditors that you can find on social media. Because a lot of those individuals have exceptional knowledge of the law, the Constitution, and all different treaties, particularly about specific jurisdictions. And even then, they get arrested often. They'd get lawsuits won as well because they know the law, right? But oftentimes, my opinion, they're not acting very prudent in their behavior. So meaning very conservatively reserved. They're doing it to challenge, right? Because they're auditing. So you have to present situations and scenarios that for an ill-equipped law enforcement would goad them into performing uncivil, which leads to civil lawsuits, right? So in order to avoid such things, act respectful, be cordial, do not be threatening, always de-escalate, which oftentimes comes across as doing exactly what they say when they say it and how they say it, and nothing else. Don't challenge them. Don't give them a funny look. Just accept, right? Because that's another thing about trust. Always accept. Because you can always challenge on paperwork. Rescind a contract. Rescind a signature. That's knowing the law. So, I, since a very young age, have this horrible reaction to figures of authority, always, including law enforcement. And it's I cannot stand it because they're always doing shit they should do. And I'm all about being fair and just, which if you're doing justice, people going against the law runs right up against that. So I want to do something right then and there, but that would be a bad action, right? Because just because there is a particular injustice occurring doesn't mean it can be corrected right then. And unfortunately, the way the legal system works, it could take a long time to get that remedy.
So would that give you the opportunity to file like a counterclaim and then with criminal complaints?
Yes. Right? Because it's all about having the correct documentation, which usually would probably be, you got video cam footage you have on your person, or someone has on their person or their body, hidden recording devices, so that the lawfare can't be used against them. People can't just make shit up and bear false witness, right? And then accurately document everything after the fact, right? Because multiple individuals within law enforcement, they do not have an acceptable, in my opinion, level of intelligence. And that's specifically because the people who created the organizations and run the organizations put a cap on the intelligence of the police and law enforcement. So they do not want intelligent people who can rationally handle things. Mostly they go for people who are unhinged, lower than what you would want for an intelligence of someone who should know the law and enforce it, and people who are prone to violence. So given you want to perform the most prudently, we should all assume every law enforcement agent we encounter is the worst type we could encounter. They want to hurt us all the time. Make that your assumption, because that's prudent. And act accordingly. If someone wants to hurt you and they're approaching you and your belief is that they will hurt you, unless you do exactly what they want, then we have to act in a manner that we may not personally like in order to get the result that we need. And if something happens, document. And let's not forget, there's all like the different writs that can be performed, like the writ of habeas corpus, the release of the body. Because all the things that happen in courts, administrative courts, excuse me, are against the trust. The body is merely the surety of it. But without the body, which should be within the corpus of a different trust, one trust cannot pretend to be another trust and administer that trust, because that's fraud. That's why we all need to have trust set up. So we're trustees and the commercial entities are inside of it. Because then some other trust can't come along and say, well, since there's no trustee, I'm going to act as the trustee. And I think it's best that it's put behind bars. And since that individual over there said that they're the name of this commercial entity, and they said, I understand, which means I give up my rights and I will follow all directions under your federated listing, we're going to put it in jail, which is all about knowing the law. So, this starts to sound a whole like First Amendment auditor stuff, but they know the law. They know a lot of this stuff. So we need to know a lot of this stuff. The auditors are just there to audit. We just need to know it because it's just prudent. So, yeah, it's a lot. Everything that's in this group is welcome. Start here. This is like the beginning of the knowledge, so you can figure out what you're missing to go find the rest of the pieces to learn it, to be a good trustee, to be a good fiduciary, to be a good steward. And there's a lot in the group, but not everything is in the group, if no one has noticed yet. It's just a good starting point. and it's an overwhelming amount of knowledge. So I hope that addressed your question satisfactorily, but it's a lot, and I use specific words sometimes for a very good reason.
Well, I guess you could add to it.
Say again?
I said, can you hear me okay?
Now I can hear you fine.
Okay. So I was just wanting to find if you had like a, your declaration of status and things like that, that you were, for them to know or you to be put on a list, like, I did a passport and it seems like they put me in a category of U.S. citizen. And so when you're a U.S. citizen, you're like, well, I operate a U.S. citizen. I'm not actually a U.S. citizen. Then you got to have to go into that whole explanation of that it's a legal fiction, basically.
Right.
So when you were saying that one, or she was saying about that they're supposed to ask you if you're a U.S. citizen, and then that you just, if you say yes, you're putting yourself into their jurisdiction, and so that's the thing that is I don't think would be a prudent, like you say.
Right. Because it's the way they get you, because it's just like there was a traffic ticket issued, a citation. I received it, for example. Show up, they say, are you Stephen Palmer? Now, first off, what's the you that they use there? Are they talking about a sheep? Are they talking about YOU? Is it all lowercase, capital Y, lowercase OU? Is it capital YOU, which could be an acronym for something? And then did they say that name in all capital letters? In which case they're talking about the trust that was issued by the federal government, specifically Social Security Administration. So, there's auditors that have had this discussion in courts, right? But this is just like minor issues. If I said, yes, okay, congratulations. I, the physical living man, have just said I am a corporate entity, a dead fiction. Bam, got me. And then they just start reading out all the things, and then they say, do you understand these charges as I have read them? And someone not knowing will say, yes. Congratulations. You just accepted and willingly admitted to being part of the federal government, because the all capital name is a federated entity issued by a federal government, and it's got federal laws, and it has a federal status called United States citizen. And all the laws, statutes, and codes are what? Regulations specifically for the federal government and all of its employees and assets. Well, that shouldn't apply to a normal person unless they say, yes, that's me, or I understand. In which case you got them. Right? So this very simple example of how they catch people all the time, which there's probably a great reason why they didn't educate everyone in law enforcement on asking the question, are you a U.S. citizen? Right? Because if everyone knew about it, then they would say no, because I'm not. Right? And like, I got my passport here, and wouldn't you know it, there's nowhere in there that actually could tell me if I'm a United States citizen or not. It does say I'm a United States national, or, I'm a national of the United States of America, but it doesn't say in there U.S. citizen. But that information also isn't available to be seen on our side. They can see it. We cannot.
Is your name in all capitals on your book?
On my book, looking at it. Yep.
See, that's the thing,
corporate entity.
That's the thing that flagged me. I was going, well, I just got this new because I just reordered it, and I even did the letter of declaration of status. So I've got to actually send them another letter now and just say, hey, you made a mistake, and I need these redone.
Well, it could also be a thing. Because you have to go back into the theory of these are commercial vessels, right? and they're in port.
Right.
So when you travel between federated states, and a nation is a federal state, you need to leave one port as a commercial entity, and you need to report through the, right? Because there's the port of departure and the port of arrival. And those corporate entities, corporate vessels, commercial vessels, which would be the all caps names, need to be tracked. Now, I didn't sign my name in all caps. I signed as a living being in the proper case. So I'm merely the beneficiary and the witness to this corporate vessel.
Yes,
Right.
that makes sense. But there was this one lady that she was explaining something about, doing her name change, and if I was to do that, I would do it in all lowercase, and that way you would have that, you're operating in commerce as, the living being operating your vessel, the all caps. That's the way I see it. Is that clear, or have I got that wrong, or?
I mean, it all seems to be theory, right? Because there's no real clear-cut evidence
Yeah.
that it works,
Right.
right? Because the only way that an individual will be able to properly demonstrate would be if they acted only upon the rules of their God. And since the federal laws specifically forbid financial institutions with interacting with individuals, no individual who acted in an appropriate manner would interact with any financial institution or federal entity. Can't do it because the living and the dead cannot communicate. Can't do it. And that's what all the federal entities are, dead entities, right? So when we have our identification documentation written in all caps, we are acting on behalf of a dead entity. The dead isn't doing anything, but we are getting the dead to interact with the other dead. Otherwise, the living couldn't. And for some individuals, especially the ones who are new, this seems like a very interesting stance to take, but all of the principles that run all of the things in this world are based off of very, 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 very old teachings and rituals. All of it. So there's a mishmash with all the different religions and nations out there, which is why there's conflicts to some degree. But that is how it is. That is how things have been, and that is how it will be until there is no such thing as nations status. It'll just be the living. But until we get there, we have to deal with this mishmash of crap.
Yeah.
And the best way to do that is to know the law. So, good question. We'll preserve it so that others who come after us, who have less knowledge than us, will be able to reflect on it.
Thank you.
You're welcome. Thank you for asking.
May I? I have a
Please.
question.
Okay.
The father of my child, where we live in a home where we abide, and his mom previously owned it. She's now deceased. She was suffering with cancer, and she needed to pay for some bills that she didn't have money for. So she got an extended line of credit, it turns out, and she had 10 years to pay it. So the loan, it was paid on time and all that, but then she died. So the bank allowed the son to take over the payments, the father of my child. and he doesn't know anything about the law or any of this. And he came into financial hardship and was unable to pay the bill. How would I go about and sort of on the lines of elderly abuse, because she took out a loan which was paid for upon her signature, and now they're threatening foreclosure. What would be the first step that I take in order to remedy this? And if they won't let me see any of the paperwork, I've asked, even though he allowed me to go to the bank and pay the bill and all that, and they know me there, but they won't give me any of the documentation because it's not the lady. And the house is still in probate. The son and his stepsister, who is not interested in the house, are on the will. There is a will. They're both equally entitled to the house. She doesn't want it, the sister. And how would he get the paperwork when nothing is out of probate, and now they're threatening to get to foreclose on the home?
Well, first thing would be to be recognized as the executor of the estate of his late mother. And that's, since it's already in probate and there's a will in place, if the executor has not been identified, he merely needs to petition or submit documentation to the court for acknowledgement as the executor of her estate, so that everything can be administered appropriately. Because if an executor doesn't step up, the state will do it and they'll take everything as much as they can. And then they'll say, you're welcome, like they did you a favor. As an executor, he would then have the authority to demand the documentation from the bank. You'd need to coach him on the private side of banking, particularly to request, the securitization of her signature for the note, the escrow account that was set up upon the redemption, maybe even threaten them with the lawsuit, because they would need to demonstrate in a court of law that, one, they provided consideration for that financial transaction for the loan. And if they can't demonstrate that they put up consideration for the loan, it's like she put up her house as collateral. What did they put up? If they monetized her note and used her note as the collateral by funding it into a secret escrow account, well, they didn't put up consideration. That makes the contract fraud and null and void ab initio. So that's the kind of stuff you'd need. So, like, first and foremost, there needs to be an executor of his late mother's estate, and the executor needs to go to the bank to demand all of the records, including the forensic audit of all of it. Then he'll be able to see it, and if they can't produce it, because there are laws in place against banks lending their own capital or their depositors' capital. So they either admit to committing fraud or they admit to committing fraud.
Also,
That's kind of how it is.
The original bank foreclosed. It was called Bank of America, and now PNC has the loan. So what would
they need to have all the documentation. All of it. Because here's the thing, if they separated the promissory note and the mortgage, this is a law. If those two things are separated, there's no more loan, because those two things are joined at the hip.
I misspoke. It's a Midwest bank. something like that. I forget. I miss. It's not called Bank of America. It was Midwest Bank of America or something like that along those lines. But they're gone.
Oh, they're gone. Like that bank dissolved or was bought out?
Yes, by PNC.
Perfect. Well, once he has to become the executor, right? Because without being the executor, he doesn't have the authority, and they could just say no. Anything that they provide before that is merely they're being cordial, just so they could say, we did the best that we could. But the executor, they can't deny it, because the executor needs to see all of the records, all of it, just like a trustee would, or a fiduciary for a trust would. They don't have the legal capacity to say no. Otherwise, they can get pulled into a lawsuit and a stay put in place until everything is resolved, and which will probably show up as them committing fraud. So, must have an executor, which is legally, he's the one who has the say on what happens legally. I mean, courts are involved because of probate, because there wasn't a trust involved, but the executor can still oversee probate to make sure everything is going to the benefit of the estate, not the courts.
Thank you.
Absolutely.
So who sees these messages on this, when you hit your mic to unmute it, and then it's got messages to the right down at the bottom? You don't see those messages?
No, I see no messages in this chat because I'm hosting and recording. So if there's anything that's in the chat, someone would have to say it out loud because I cannot read it.
So does anybody else see the messages? I guess that's what I'm asking. Who sees them?
I mean, all of you could see them. Like if I was doing video recording, even then it wouldn't record the messages. So that's why I have the separate a channel dedicated just to the chat. It's called Chat RECOUPERS Live Session. So if there's any chats particularly associated with this live, put it there. Because if it's not in there, it will not be saved. I'm trying to resize my window here. King Richard, I see you in the chat. I hear you've been doing great things in Texas.
We're trying.
Awesome. I've been really busy, so I haven't actually been listening to any of the lives you guys have down in there, but I see all the chat being posted about it.
Yeah, we really don't have a subject or anything particular. Somebody comes in with a question and it takes off.
Yep, that's what I'm doing today. So, anyone else have any questions or successes they would like to share? Anything recent? Talk about the weather.
I have a quick question. Dr. Heather reached out to me personally just the other day, and I haven't seen her active in the group in probably months. I've only been in the group a month and a half, but I've read through a lot of the chat back all the way to the beginning, and I've had a lot of people from the group reach out to me trying to sell me stuff. So
yeah,
I was just curious, does anybody know if Dr. Heather would have reached out to me? I don't understand why she would send me a private message, and I've never talked to her about anything in the group. So I just didn't know if I should block her like I've been doing the other people. And she's not in the chat today, so yeah.
All right. So Dr. Heather was last online. I checked right before I started the live. She was last online on 10/16. Because she has stuff going on in her personal life involving her family, right? So that's why she's not available, to the best of my knowledge. That's the last information I got from her. There are lots of scammers. I believe at last count that I was aware of, Dr. Heather had 7 imposters. I know I have 3 imposters, right? And the best and quickest way to know if it's an imposter or not is when you receive the first message from these people, when you open it up, it says groups in common. If there's nothing there, that's a scammer, right? Because if you don't have a group in common with them, that means they're not a part of RECOUPERS or whatever other channel. So if Dr. Heather sent you a message, that individual should have at least RECOUPERS as a common group with you. I'm not saying Dr. Heather doesn't reach out to people, because she does. And I get spam a lot. And I haven't said it recently, but for anyone who does get spammers or scammers and they are in RECOUPERS, screenshot that and put it in like the off-topic comms or message me directly, because I want to remove them from the group, because I probably removed 10 of them yesterday. And this is just without anyone's assistance. And I know there's a lot in the group, because there's a bot that gets in the group and it's just really quiet and it just sits there and does absolutely nothing except for identify users, and it gets it to another bot and it goes to someone else, and then they send out to a bunch of scammy messages. I know it happens because my background is also in tech, and it's super easy to do. But in order to remove them from the group, we need to know who they are. So if anyone in this meeting now or listens to it in the future, you receive messages from someone who claims to be in a like-minded group as you, and they're saying, well, so-and-so, oh God, what's that person's name? Miss Scarlett, especially. Oh, Miss Scarlett really helped me with crypto. I received like 30% returns, blah, 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 blah. Nope. Screenshot it, report them, send it to an admin. Definitely screenshot it, because I'm sorry, I can't just take people's word for it. And someone says, this person was being mean to me and trying to scam. We need proof, right? Like, documentation is everything. So that we can get the scammers out of the group as much as possible, right? So thank you for bringing that up.
Thank you.
Absolutely.
I don't know what y'all gonna do when we move. We really ain't gonna find shit.
Who that? So,
Movie.
but
Who's moving?
right.
When he move, he
Like-
can't be mad. He didn't-
Also, when we got these regional groups, if anyone hasn't joined them, if anyone listens to this later on and they're like, I'm trying to find someone local in my area, we have regional groups. They're in the affiliated groups. This particular name of it is RECOUPERS affiliated groups links. They go into particular areas.
Go to YouTube. If you don't
Those
understand.
groups are specifically for making connections with locals in your area or within your state to help further your knowledge and study. I mean, it would be great if we just had cool hangouts everywhere, but that's not what they're for. When you join them, you must share your residence location. It'd be great if you shared your city so that if others are in the area, they could find you. But your state is sufficient because others will find you. If anyone fails to do so, I will remove you. And I do it a lot because we want to keep them free of bots and scammers. Right? Just like this carry on from the previous comments. So in order to effectively make sure that there's no or as minimal amount of scammers as possible, I remove people a lot. So just want to put that out there because I haven't mentioned it in a while. If you are looking for locals, the regional groups is a great place to find specifically where you're at. There are a couple of areas that are like in multiple regions, like Arizona is in the Southwest and the West region. So if you're in Arizona and you join one or both of those groups, you got to share. If you try and join multiple regions and you don't have any good reason for it, I might just remove you from all regions. Just something to be aware of, because I want to act prudently to protect everyone. And if you are a human and I remove you, you will have to contact me directly and prove you're a human so I can unban you. And I'm not the only admin that does this. I'm just the one that's vocal about it. That's my soapbox. All right. Anyone or who has a question? Because I know people have questions.
Stephen, it's like Patrick Devine when he started his calls. It was always who sent something out and who got something back, and it's just dead silence.
Right, and I get it because some oftentimes there's a live. You're in a place where you can't speak, so you don't. Which I get it, but or someone's thinking like, oh man, I have this question, but I think it's a really dumb question. Yeah, guess what? It's not. It's not, right? Like this type of stuff is like so massive. If you've got a question, probably 5 out of 10 other people got the same question. They're just too self-conscious to ask it. They just don't think it's worth asking. But the intricacies of all this stuff is so fine. The way in which a question is asked determines many things, right? Because if you change the location of maybe 2 words or you just swap them, it's a completely different question and the nuance is completely changed, right? So if you have a particular question, say it, because the way it's said will change the response.
Hello, this is Tanya. How you doing, Steve? Everyone in the group with Cooper's group. I thank God for you all. That's my gratitude to you all. So I do appreciate you all having this group. It helps each and every last one of us on our success, our journey.
Absolutely.
But I do have a question.
All right.
So I have submitted a 1041. First, I submitted my 1099 A's and B's. Then I already submit a documentation. Then they sent me a check over. It's a small check for 1099 OID process, and they sent me a check back. And I wanted to transfer my credits from the estate to revocable living trust. So once after the lady told me to file a 1041 at the IRS, I filed a 1041. But then when I called back, they saying my case is under case review and I got to wait 60 days. So is there something I did wrong, or should I just wait? Or should I enforce it with the 843?
Well, I mean, if that's all the information they gave you, you really don't know much of why they did anything that they do, which is very true. Because you could have done everything right. They just don't have a person available. So they said it's under review. Or, right? I mean, because if there's been massive layoffs, they're shut down presently, except for like, air quote, critical operations, whatever that means. So I got stuff and I'm waiting on a response, but because of the shutdown, I'm pretty sure it's going to be delayed. Because I was supposed to have gotten a response on the 22nd, but we've been in shutdown for quite a while at this point. So I'm in the same boat. I don't know why they said they needed more time with documentation I submitted. They didn't tell me no. They just said they needed more time. So I'm like, cool. I really don't know why they need more time. So it wouldn't, in my opinion, be in your best interest to do an 843 because you don't know what the holdup is. I mean, you could try and harass them about it and be like, why is it delayed? and they'll probably say, oh, someone will get back with you, which you know is a lie. They're just saying it. And by someone, it could be like, a printer that's out of ink. They'll print off a document in like 2 weeks. At the moment, it's just not much can happen due to the shutdown. But, they did just past couple days pass, that reform on our notices to explain things using more words. So they can kind of, give us explanations of like why something is. So hopefully whenever the IRS does come back online at capacity, whatever diminished capacity it will be in, that we'll see that. So they can actually tell us like why they need more time or what they had a disagreement on, what item in particular they're asking about, instead of just being like super vague, because that's not beneficial, period. Because like last batch of documentation I submitted was like 23 pages. They didn't specify anything about what they needed time for reviewing or verification of. So it's kind of like a hope and a prayer. And who knows if they need more time, or if the person who that was going to be doing it like quit, got laid off, got reassigned, and there's no one else to do it, so it has to sit around until someone gets to it to reassign it to someone else so they can start over again. But it's just where we're at right now.
Oh, sorry, Stephen. Would that information be on the transcript, like the holdup or any kind of issues?
Well, presently you can see it because you have a code. But beyond the code, the codes can tell you quite a lot, but they won't tell you specifics. The specifics, or more specific, comes when you get like a letter, and those have their own particular codes on them, right? But even then, it's written in legalese, so you have to decipher it to try and have like a understanding or grasp of what they're trying to tell you, really. Because they like to, not be direct. But they're the government, so they don't like being direct. But hopefully with the stuff that just got changed, we'll have more accurate explanations. So, like I know on mine, I believe I have an 810 on one of my tax years, and I think I have an 830 on a different one. Maybe it's an 840. And these mean two different things. So, and I don't have any paperwork, and there's no letters that have been issued on my tax account that I can see, but they're also in a shutdown, so they're probably not doing anything related to my stuff, as far as I can tell. But we're in a waiting game at the moment. So, I mean, I've read it. Some people have posted like they tried called for several days on end and they can't get anybody. Like, well, we're in a shutdown. There's no one there. Or someone tried to go to a tax office. There's no one there. There's just a security person. That's it. There's no one in the office.
Stephen, I sent in a request to make a change on one of my EINs in March 22nd. And I've received 2 60-day notice. We need 60 more days. So it's just, right. That was in March. So just
that's crazy. Because that only screams, we don't have the personnel who know what to do. Because if you're, in that case, like if you're just changing the information related to one of your entities, it's okay. Validate the information in the request. If you can validate who it is, make the change. Log into the system, update, save, done. You can't validate, send out a letter for verification of identity, validate identity, complete the request, save, done. They constantly saying, oh, we need more time. It just screams we don't have the personnel, or whoever's there just doesn't want to do their job.
I think it just sits in a pile, right? And then if it hasn't been responded, there's an automatic message it just sends out.
Right. Right.
I had one of my issues. I received we need a 60 more days, and then the following day I received the actual response. So somebody sent it out while but it was just processed, minutes later, I guess.
Right, because it's like an auto trigger, like we need more time.
Yep.
Right, and like depending upon your issue, they say, "Hey, we need more time." Trustee fiduciary says no. Because they have a very particular set of rules they have to follow. Just because if someone's incapable of doing an action doesn't mean they don't have a requirement to complete it by a certain time. Right. So, because that's the way that their requirements are written, is actions must be completed within a specific time frame. They're merely asking our permission to give them more time. Right? Tacit acquiescence. Which is, really goes into the whole like sending in promissory notes and bonded promissory notes and negotiable instruments and self-executing contracts. Tacit acquiescence is a very valid and always currently used commercial principle. Like you get a letter from your credit card company saying, "Hey, we decided to change our terms and conditions and it's going into effect on this date. If you like it, don't do anything." That's tacit acquiescence. If you don't like it, write us back or cancel your account. Haha. So we can do the exact same thing they do. Commercial entities. Just be sure you know what you're doing.
I have a question. Don't mind.
Yes. Linda or Thirst, whichever.
Go ahead, Linda.
Thank you. Greetings to everyone. I am new and a little nervous, but I'm gonna get it out. And
That's okay. Welcome.
Thank you. I wanted to ask a question about trust. I did the CYC process, and my question would be, any trust that I create, do I need to do that same process, or is it only for the living revocable trust? Like sending out the different paperwork to the Secretary of State, the Attorney General, etc. Is it just for that particular trust, or you need to do it that way with each trust that you create? I hope that makes sense.
You mean the non-decedent letters?
Yes, correct.
You only need to do it. Well, okay. I won't say this. That part of the process was there in order to correct your status or to correct presumptions, right? Because since when people pass the air quote age of majority, they claim that they are full-fledged adults. And some people, unbeknownst to themselves, continuously prove to be a minor. So the presumption is they're still a minor, which is why when someone goes to a court, someone must act as a trustee because there isn't one. So the non-decedent letter package is specifically to correct the presumption, to make the separation between the living being and the commercial entity that shares a very similar name or sounds the same name, completely different spelling.
Correct.
That's the purpose of that. It shouldn't need to be performed on any subsequent trust creation, but that is not to say that it doesn't need to be performed multiple times, because the system is always trying to pull us in and to act under the presumption of a minor so that they can act as a trustee. right?
Yes, I definitely
So,
understand. And I thank you for that because I'm still in the process of, how they say, trying to correct my status. I even did the paperwork. I had a meeting with Social Security, and then they sent me to the courthouse, and the courthouse is saying, well, you need to pay this amount of money. You need to do paperwork as far as the FBI fingerprints and things like that. And I'm like, these are, my things. This is part of me. I didn't feel that I needed to do that, and it kind of frustrated me a little. Um, I have another upcoming appointment with Social Security to try to change my status to get it corrected. And I was just, I guess, making mentioning of this because I wanted to get your thoughts of, am I doing something wrong? I have all of the paperwork that was told to me that I needed. And I'm just kind of curious to get your opinion on what are your thoughts? Am I doing something wrong? What would you suggest? And I yield.
well, I got two things to say. First one is more just me saying it. Second one requires your input. Firstly, that Social Security Administration, if you have sent the non-decedent to either the Department of the Treasury or the IRS, you don't need to talk with SSA at all, because service to agent is service to principal, and service to principal is service to agent. Right? You've already put them on notice. So if they don't fix their stuff, that's a failure on their part. They've already been notified. So any failure on their part which harms you, they are liable for. So there's no reason to talk to them. They merely are the entity that creates the trusts that get identified by names of which we are beneficiaries of. That's it. That's it. So their only role is to create it and manage it, and to make sure that the beneficiaries are merely the ones who are signing that Social Security card. Other than that, they just keep a track of who accesses the socials. That's it. So it's in my opinion, you don't need to talk with them about anything unless you need a brand new card. Regarding the courts, what are you trying to do? Like file your trust on the court?
Well, I did try to do that, my trust, and they told me that in North Carolina, we don't have to do that. So I understood that part, which means that is private. I got it. But when they told me, because I was trying to do the name change and all of that type of stuff, that's the reason I thought. And that's why I'm calling for clarification to make sure I'm getting it right. I wanted to do a name change and make sure that my citizenship was correct, which is U.S. national. I hope I'm saying it correct because I've been doing a lot of reading research, and I was just trying to correct it so that I could, how they say, apply for a passport. And I thought those were the ways that I was supposed to do it. And I thank you for mentioning the portion about when you said that each entity, once you send it to the state and attorneys, I remember hearing that, and I thought that's the way it was supposed to go, because out of the blue, someone from Social Security ended up calling me for paperwork that I had sent them back in February, and they just called about maybe 2 or 3 weeks ago, so it kind of threw me off, and that's why I was like, am I doing something wrong? And I'm just trying to make sure I stay on the course of I really want to be as private as possible, or let the entities work in commerce besides me. I hope I said that correctly.
Yeah. I'm also in North Carolina, and North Carolina is like one of those states where like it's a trust, it's private, zero requirement, and we will actually be actively resistant to you trying to bring a private thing into the public. filing it in the court. I'm like, that's amazing. Like some states like California are like, oh, it's private. We want to know everything about your life. We actually want to know what you had for dinner last night because we care that much about privacy. We want no one to have it, which is mind-boggling. So in your case, being in North Carolina, don't file anything with the court. Nothing at all. The only time that you would need to file something with the court was if you were in the military.
No.
You need to file that discharge paperwork with your local court. That's it. That's a different thing, unrelated to trusts. That's to return the body back to the land. That's the purpose of that one.
Okay.
So, yeah, in regard to trusts and the filing of the things, if a state has a requirement about needing to file it or they allow you to file a trust, keep it as private as possible. If they don't have a requirement for filing a trust, don't do it. Don't do it at all because it's private, like super secret. Unless you tell someone that you got one, you don't.
Okay.
That's the way they like it here, which is amazing considering some of their other laws they've done. But yeah, with the agencies will, not just the agencies, everything in the corporate world and the federated system will attempt to bring you back into it to be subservient to the federal laws because they want to take that advantage. So resist it, file the paperwork, keep a copy of the receipt that the paperwork was filed, keep the originals. So should in the future they attempt to say, oh, you're that thing, like, no, I'm not. I'm a living being. I was not born with a social tattooed on my body. Thank you very much. That social is tied to that all capital name, which is property of the Social Security Administration under the Department of the Treasury, under the Department of the Government. That is not me. It is not mine. I did not create it. I do not control it. We are not the same thing. And here's the documentation that I submitted to agencies declaring as such. And I have a passport that I got afterwards. Just make sure when you go through it, you do not indicate that you are a United States citizen. There's lots of debate about if that's even useful or not. But I said I'm not a United States citizen because I am not a United States citizen.
Correct.
Right.
Okay.
Yeah, we are a republic and we are a nation comprised of 50 nation states. People forget that whole nation part. Each state of the union is its own nation. That's why they all have inter-trade agreements. Otherwise, there wouldn't be a need for that. They're all independent. They have all come together as a singular union, so that integration blurs a bunch of lines, but they're all independent, right? Some of the states of the union still have within their agreement of their constitution, they can secede from the union at will, right? There was a big old war we had about this stuff long time ago. So each of the states are independent states. They are their own nation state. That's where statehood. Let's talk about nation states. So every nation within, or every state within the United States can make international agreements with any other nation they so choose on the planet, whether or not that's a detriment to their federal funding or not. So it's just a slight degree of change in thinking, and like they're all independent as opposed to the United States is one just giant entity. Those are two separate levels, two very different things.
Correct. And thank you so much for your advice. Thank you.
Absolutely. Good questions. Like, and yeah, because like you bring up good points, like depending upon where someone resides, have vastly different experiences when setting up estates and doing non-decedent stuff. So it's a great question you brought up. Thank you.
Thank you so much. And then I have one last question, because with that, and I'm in conflict because I'm not truly understanding if I'm trying to go private to a certain degree or mostly, why would I need to do a UCC at all? Because is that not still considered out there in the public? I hope that's not a foolish question, but I just needed to kind of wrap my head around that. And that's the last question, I promise, guys.
Well, it depends, right? It's like, yeah, it's in the documentation. And the reason for that is so the UCC1 filing is for a entity to make a public declaration of indebtedness. That's what it's for. So, and then the purpose for that is the principle known as first in time, first in line. The IRS operates off of this. So, and as the theory goes, because it's yet to be disproven and it's not a law, because, right? If and when an indebtedness is created via UCC and is filed, say, against a social, then any point in time in the future, if a alleged debtor shows up and says, that one owes me, great, get in line. It's not that they won't get paid, it's that they get paid after the ones before them. So if the ones that is first has, say, $500 million indebtedness, well, at the point in time where all the debts have to be resolved and it's under 500 million, all of it goes to the very first creditor on the UCC-1. If it's over that, it satisfies the first one and then goes to the second.
I definitely understand now. Thank you.
Yep, no problem. And if changes need to be made to it, that's a UCC 3, I believe. If I am wrong, someone please correct me.
That's correct. Hey, King Richard, I answered your thing that you sent me, so you can look at my response. And I appreciate you, Stephen. I love your clarity.
Absolutely. I mean, it's why we're here, right? It's a help. Because I'm sure a lot of the information in the group is in a lot of different places. But from what I've seen, a lot of that's in this group, and information-wise, isn't all in a lot of different places. Now, I've seen a lot of different people who have a lot of insight into things, and they have a lot of things, but it's usually about a particular topic that touches on a couple of other things. Not like a lot of topics that touch on a lot of things. So it's kind of why the group exists.
Yeah, the compartmentalization is a little bit confusing sometimes, but you figure it out after you're in it.
Oh yeah, especially if you're new to Telegram, it's extremely confusing.
Yes. And Richard asked me a question when he texted me like on the 24th of September and asking me if I was safe, and I was in jail actually. So I guess the answer was yes and no.
Yeah. Kind of safe.
This is how I find
really
out, Tim.
safe.
This is how I find out.
I know. So,
yeah, because they don't easily allow you to do such things when you're locked in jail because you're a minor. You didn't do what they wanted you to.
right? And there was a podunk town, and I had a canoe on my on my truck or Yukon, and it was like I had my plates, and the game warden didn't like it, so he conjured up his Barney Fife and Andy, and they came and took me.
Yeah. They just had to flex their authority. Show you who's boss.
Wow. Hi, guys. This is Teresa from Portugal. I'm so sorry it's that horrible in the U.S. You don't go to jail here in Europe for things like that. You might get a fine, or you might talk to the officer and he might let you off. So I'm really sorry you're all going through this. It's very dark. I'm sorry. So just to say hi.
I mean, yeah, I mean, it's not like they can't use their discretion. Because like they easily could have resolved that dispute with just like a verbal warning, and that's it. But
you don't go to jail for having wrong license plates here. I mean, it's not like that here. You have a whole due process that has to go through. It's very bureaucratic. It'll probably take you 2 years before it gets to the court. So it's different here. I just wanted to say I was very shocked when I started listening to all these stories of people in jail. I'm like, oh my God, what a country. Well, it's not the land of the free. So it's different over here, just to let you know. You will not get it. Yeah.
Well, I mean, there's always lots of confusion when people say it's the land of the free, because there's a lot of subtext to that. It's the land of the free to do whatever you want and to get the consequences of your own actions. They just don't say the rest of that.
Yeah.
So.
Yeah, but here
everyone is free. For
a traffic ticket or for something like that, you won't go to jail ever. I mean, you can't go. It's too crazy. But anyway. Hi, everybody. Yeah. Just to say thank you very much for having this space. Bye-bye.
Absolutely. And we got 2 minutes. So if anyone has a quick question, we could try and fit it in. Actually, down to 1 minute. Anybody have a really quick question to ask, or can we just call it a minute early?
Quick question to change the e-state. Do I send in the new SS4, or I have to send a request to change?
Hey, Niels.
Hey.
All right. Niels, what's the question about your SS4?
Because the e-state, I made a mistake on the name. Because I wrote the last name because it's a Norwegian letter, so I wrote it on the item application. I put the last name 2 times. So I put it e-state, same way, style.
Oh. Well,
they've changed something, but they've changed it. They're not letting you off easily to make a state EIN.
Right. Well, I mean, I do know there's 2 ways you can handle it. One, if they issue the number, you can update the name. That's one way to do it. Otherwise, you got to create a brand new one.
No, they won't let you. I would do that one, Niels, because if you try to create a new one, they've really changed and make it really hard. So just change the name and correct it. I think that's the best way. I mean.
Yeah. Usually it's creating a brand new one is much faster. But in those rare instances where you want to keep an entity alive for whatever reason, or keep it as it is, but change it a particular aspect, that takes a lot of time, effort, and energy, as opposed to just creating something brand new.
You can try. I mean, I don't want to try, but I know they're making it difficult. I had a very rough time.
Or also, this is a thing, doing business as. You leave it like it is exactly, misspelling and everything, just because it can just be confusing. That's a great tactic to give something a name and no one understands what it's for. Do a doing business as and change and have that name the correct name.
And how would you utilize the doing business as? Where would you put that? Would you upload it to the IRS?
I believe it depends upon where you're going to be operating, right? Because we have the different states and they all have their different rules regarding such.
Okay.
make an estate. I mean, to the banking out to the short swap. That is the purpose. To borrow
Yep.
money from the estate to the trust. So.
Yep. It's a great way to, hide things using a strange name twice.
Yeah,
Thank you.
May I ask a question? My I-10 got rejected after 2 months and anyway, because I didn't do it. Anyway, can I do the CP 575 from one trust to the estate and to get the unlimited credit?
Potentially. Do you have the 670 voucher?
I have that for one. Sorry. I have that for one trust that I'm not using, but I already have a 670. I just don't know what to do with it.
Well, I mean, it's got all your identification, or no, it has some of the identification information on it that you need to use it as a remittance. You would just have to complete it.
But what would
And then once you do that, you
Make
just
copies of
transfer
the
it.
blank first.
Yeah, have
Make
keep
copies
copies.
of it. Yes.
I didn't understand.
Or-
Sorry.
Like, make copies of your 610 voucher and use the copies. Don't use your original, use the copies.
And what would I do with it? I pay taxes, but I don't have taxes to pay.
No, it's for payments, not tax payments. The word tax is not on that document.
Okay, so I can make any payment, any bill, anything I can just use that with?
You're completing a negotiable instrument with that remittance once you complete it.
Okay.
And the details of what you need on that remittance are specific to the trust that you will interact with and what they require.
Okay, thanks.
Right. Yeah, because there are a couple of videos in the group on specifically for the IRS on what they require on their remittances. And one of them is from a guy who did it on YouTube years back and talked to him on the phone. That's specific for the IRS. For other trusts, you would need to contact their trustee, the office of the trustee, to get the information on what information they require on the remittance so that it completes as a negotiable instrument for them.
Okay.
Right. And the point of it is once it's a complete remittance, all they have to do is endorse it on the backside and they can take it to the Federal Reserve window and redeem it.
So when you say remittance, it's, for example, a bill or a light bill, I would pay with the 670 voucher as it were a check, right?
Not exactly a check, right? Because a check is a draft upon an account with an established amount in it already. Okay. So not exactly the same. But like in a similar fashion, once you populate a check and you complete it, once you mail it, it is a remittance.
Yeah.
Right? Because we're talking about the difference between legal and lawful tender. So it's just you have to complete it. The 670 needs to be completed to be a valid remittance.
And when you say completed, you mean endorsing it and putting the value and everything?
Yeah, all the things that the receiver requires in order to utilize it as a negotiable instrument.
Okay. And could I use that to pay my all caps bills or just the bills of the trust?
Kind of, right? Because like it has to be something that's received by an entity that will accept negotiable instruments as lawful tender. Right? And if they're a commercial entity, that's a key point. They have to be a commercial entity. They fall under the UCC and the International Commercial Code. So all the details are spelled out right there.
So basically it would be an IBOE almost. It's an instrument.
Yeah, because an international bill of exchange is a negotiable instrument.
Yep.
Yeah, it's like, because if you just have to follow the correct procedures and the correct law. Because if they say, oh no, we're not going to accept that, but they don't return it, congratulations. They just met the requirements of discharge.
Yeah.
If they reject it and they return it, well, then they just completely rejected it. That means it's a discharge.
Mm-hmm. Yeah.
Because that's the law.
That's the UCC code. But
right.
The problem is here in Portugal or in Europe, they supposedly don't recognize the UCC. They put in all these other codes, but everybody's contractually binded by the UCC if they're in international commerce. So.
Right. Because they go by the UCC and the International Bills of Exchange.
Mm-hmm. Yeah.
Because if they don't operate on those two principles, they're not within the Western financial markets.
Yeah. Okay, thank you. Because that's where I've been hitting some walls because they rebut with codes. But yeah, the UCC is superior to any local code.
That's right.
Yes, thank you.
Because they operate on the Federal Reserve System in SWIFT.
Mm-hmm. Okay, thanks.
So thank you everyone for joining. I will close this out and get the recording up as soon as I can. Y'all have a great rest of your weekend.
You too. Thank you.
Adios.
Bye.
Adios.
Appreciate it. God bless y'all.